A very good morning to one and all present here. I am Aisiri Madhukeshwar Thupar from 5th year KLE and I shall be moderating today's session. Land is the most valuable asset and a determinant of wealth to nearly all the Indians. Securing and protecting vulnerable people's land rights is essential for bringing about a fair and prosperous society. An immovable property over the last several years has seen exponential growth in demand, and this shows how important it is to understand the concepts and laws related to the land. It is with immense pleasure that I welcome you all to this special lecture on Conceptual Moorings of the Land Acquisition Act 2013 and the Land Revenue Act 1964, organized by KLE Society's Law College, Bengaluru. I now invite upon the dais Ms. Swati from 3-year LLB to introduce the distinguished guest for the day.
It is a very happy just inform my teacher
Good morning to all present here, Honorable Chief Guest of today, and my dear friends and faculty members. On this occasion, we are happy to have with us Professor Dr. K Ramesh sir, and it is my pleasure and honor to introduce our guest. Professor Dr. K Ramesh sir has done his education of Bachelor of Science in University of Mysore and has completed his Masters of Law in University of Mysore and has also completed Doctor of Philosophy in Law from University of Mysore. Professor K Ramesh sir has been professor at National Law School of Indian University since June 1992 and also served as University Vice Chancellor between August 1st, 2019 to September 25th of 2019 and also has teaching experience of over 40 years. And Sir also served his service over 2 years as Commercial Tax Officer at Government of Karnataka. Sir's specialization includes international law, human rights law, environmental law, and natural resource management law. And Sir also founded 3 centers excellency at National Law School of Indian University, Center for Environmental Law Education Research and Advocacy in the year 1997, Common Sense in the year 2009, and Environmental Law Clinic in the year 2012. Sir was also a senior Fulbright Fellow in the US in the year 2005 and 6 and an Environmental Law Fellow in the year 2006 in Environmental Law Institute, Washington, DC. Sir was also a founder of editor of Indian Law Journal of Environmental Law and also published over 60 research articles and 5 books. I extend my heartfelt welcome to you, sir, for this occasion. Now I request Malti sir to welcome the honorable guest by presenting the token of appreciation.
Okay, sir.
Thank you, Ms. Swati. I now request our guest speaker, Professor Dr. K Ramesh sir, to address the panel.
Sir, once. actually put mail off with us.
So that they cannot see them. The staff will
Yes.
down to
You observe, but
you can get the chairs to no formality. It's a class. Very good morning to you all. As we set things up for us to get into a conversation on the subject, you're all students of which class? Final year. Oh. Then my job is very easy. Can you hear me in the last row? With this mic on or without mic? I don't think. Yeah. Are you able to hear me? Okay, fine. There is nothing special about my lecture here. It is a just normal routine lecture as any of us would do in a classroom. And you know, in law teaching and law lecturing, there is not much of a lecture involved. There is more of conversation. There is more of interaction. And there is more of getting to know from each other as to how much the other one would know. And then if the teacher is found deficient, the students coming to the aid of the teacher because young minds, very fresh minds. Thinking out of the box is something which is part of the DNA of a young fellow, and so would be able to supply the omissions and contribute to the learning. So I have this conversational thing with my students all the while. Whenever I get into my normal, usual kind of a lecture, I will continue with that here as well. Conceptual moorings of land laws. What is so special about land laws? I'm happy the moderator. You're the moderator, right? Yeah. So you will moderate me also if I go beyond 1 o'clock. 1 o'clock we are supposed to conclude. No? And you will also moderate if there is any problem where questions asked by them I cannot answer also. You will help me. Please. I look up to you because she gave a very good starting point for us to get into this conversation on land law. And since you are the students of final year, there cannot be any batch of student who would be able to appreciate the value of this subject than anybody else. Your juniors may not be able to appreciate. All the courses that you have studied so far can be related to this law, without a single exception. You have a tax expert here. You can definitely bring in this land law conversation. You name any aspect of law, no law is exempt from any inquiry in relation to property, resources, land. Land is symbolic of property. And in legal learning, I must say that if you keep it in balance, all the laws in the world on one pan and law-related laws on the other pan, land-related laws far outweigh all other laws put together. Mastery over land law, I assure you. Especially for those who want to get into administration, civil service, ideal. What does this IAS fellow will do when he get into service? A district collector administers land law. In fact, I used to get some of these very, very senior bureaucrats, secretary rank fellows, to get into the discussion of the subject with my students. This is what they do day in and day out all through their career. And when you break into civil service, if people know that you are very well equipped as a lawyer in this subject, I assure you that you are a hot property, most sought after officer. Not just in that, even in law practice, and I don't have that experience, but friends like him have experience. They can vouch for what I'm telling you. If you have mastered this, law practice is a child's play for a practitioner and for a judge. So the sum and substance of it is, as very nicely in a crisp way put together in a few lines by our moderator. I just don't know your name.
I see. I see.
ICD. Oh, that's a great name. You know the meaning of ICD? What is it?
Goddess Lakshmi.
So she is blessed by Goddess Lakshmi to give the very crisp, edited version of what the significance of land law is about. So, given this kind of importance for this subject, and the kind of experience that you had in these 4 years of your study here in this law school, I want to walk you through the concepts. And why should we know about the concepts? As students of law, you should be able to appreciate that once I know the concepts, and once I am clear about the concepts, they actually form the heart and soul of any law. The entire land law can be understood with some 8 to 10 concepts. And if you know the meaning, depth and dimension of the application of these concepts, reading through the provisions, most of it is procedural law, very mechanical, and trying to get the real hang of the subject becomes easiest. And that's the reason why when my friend Professor Mahantesh asked me I should come and talk to you about land law, any specific area that you would like to discuss, I said, let me discuss the entire land law. No. For our academic sessions, time is very precious. That 1.5 hours you spend, you should cover some area. My problem is I don't cover any area any time. As a teacher, I have never covered anything. I go into a discovery in a classroom along with my students, and together we explore the content and contours of that law. And at the end of the day, we gain some kind of an insight or a knowledge, nothing more. Law learning is all about that. It's a journey of discovery. And the beauty with law is every time you get into a journey, you get new images, new scenes. The scenario is not the same as you might have traversed earlier. Precisely for this reason, law learning, law interpretation is a very dynamic process, just like the human mind. It has to be because law needed to get attuned to the changing times and be able to answer the problems of any given point of time. It cannot be stagnant. And so you get into a discovery all the way. New meanings, new ideas, new interpretations. Otherwise, courts of law would not have been required at all to adjudicate on any legal issue. Just a mechanic would have done that. If it is mechanical application of law, you need a clerk. You don't need a judge. You don't need a law practitioner. These are the ones who are going to give new insights and meaning to the law, to see how relevant that law is to a particular problem situation and resolve it. Now concepts. I don't mention any concept. I will ask you now. I will think. So this is not whiteboard.
Whiteboard ಬೇಕಂತಲ್ಲಿ ಹೊರಗಡೆ
I think that's better. It will be a little messy here. Sorry. What comes to your mind when you think of land? Please don't tell me urban land and rural land. That's for the common man. For a lawyer, how do you relate land with the government? Because all laws are relations. They set relations. They determine relations. They create status. They recognize positions. Rights and obligations are created through law. And so, when you think of land, how do you relate land? What's its relationship with the government? Any one of you? No?
Government is the eminent domain.
Eminent government has eminent domain over land. Oh, this is a new expression. Let us explore that. I deliberately introduced a little mischief just to mislead you. Government doesn't have an eminent domain. It is the state which has the eminent domain over everything. Even if I had started my lecture by telling you that government has eminent domain, you should have corrected me. There is a difference between state and government, as you know. State or nation. And state, as you know, is this sovereign. Who is sovereign in India? We the people. So, we are the state. How can you reduce your status to that of a government? Government does not have eminent domain, we have. We the people of India, we gave unto ourselves the constitution, the fundamental law of the land. How can we be reduced to something lower than a government? We create the government. And we will have representatives, our representatives in the government. And the people in the government are supposed to do what? They do. Have to administer the law. And on our behalf, not by themselves, exercise this eminent domain. It is just an agency here. He is not the master. The government is only an agent. And as per our dictate, translated through a legislative law, they start exercising the eminent domain and administer the law. They don't even actually exercise eminent domain. They administer the law. Okay? And this administration, who gives them the power to administer? Of course, we the people are given. I want a slightly different answer now. Otherwise, a common answer for every question, then you will be repeating the same thing. I'm slightly changing the track here. How does the government get the authority to administer? Is it something the way it wants to administer, or how does it administer? Or for that matter, land. How does it administer land?
Constitution and other laws.
No, what's the authority for exercising that power?
Representation of people, sir.
That's your lawmaker, who is our representative. The executive wing, I'm referring to the administrator here. The one who is administering the law, he cannot do anything and everything that he feels like. What is that anchor? What is that guiding star which gives and sets the direction for him to act in a particular way? Which is that purpose? I'm giving you enough clues. No, preamble. We are past beyond that. So from the constitution, we have gone into a statute now. Sorry?
Welfare of the people. Public policy, welfare of the people.
What do you call that?
Public policy.
Public policy is for the policy maker.
National welfare.
Welfare state.
What the purpose?
Public policy.
Precisely. See, let's use legal expressions. So, exercise of public purpose gives him the sense of direction in exercising the public domain over land and all resources to take care of the public good, or the, to use your expression, public welfare. So land management, land administration, land use, putting land to different kinds of uses. He cannot do it at his whim and fancy. You, the administrator, you have to act for public good, and that which is good, for which purpose you can put the land to use. And when you refer to property, you have two kinds of property. Can the administrator deal with private property? I refer to utilization of land. Private land, my property. I have the title, Khata.
Land acquisitions.
But he cannot directly administer straight away. If it is in the private domain, no, sorry. He can only administer the public resource, that which is in the public domain. He cannot touch the private one. And we are referring to the putting to use any resource, and it could be public resource primarily, which he administers and puts it to different kinds of uses. The paramount purpose is public welfare. Okay. In the exercise of this eminent domain, in putting land to different kinds of uses, does he have power only on public property? As a general rule, yes. But supposing some private property is required to be used for a public purpose, can he just pick that? Look, I see you have a property there, we need it for a public hospital. We are going to put it to use. I have the gun. And I'm going to use it for a public purpose, and you're using it for your private residents, and you have such a huge farmland. Can I, as the district collector, just issue a notice to her? You just leave. Hospital is coming up there. No. Then what I should do? I should acquire, right? I should start the process of acquisition. I cannot directly. I can indirectly. It's a. I cannot directly and immediately use private land, but I have the power because eminent domain gives the power to the state to do anything and everything with regard to the resources because sovereign is supreme. And this sovereignty actually manifests in two forms, as you know, constitutional law, you're right. External dimension and internal. The external is as an independent nation, as a nation equal to other nations irrespective of size or population, equal to any other state, any other country in the world, has complete, exclusive, sovereign right over all that which is there within its territory. All that which is there within its territory, yeah, personal property. So the state has this phase at the international level that it can do anything with regard to private or public resource, doesn't matter. There may be procedures. We will see about the procedures. But when you are the state in United Nations, I as a sovereign state, that's what you must have heard, External Affairs Minister must have thundered in his interview with some of the journalists abroad. What do you mean? I am 140 crores strong state, sovereign. And how do we deal with our affairs is our lookout. Nobody shall dictate anything to us. That's the external dimension of sovereignty. And there has been a recognition of it under international law that every state has a complete sovereign right over all its resources, all its people also. That's exactly the reason why when one is able-bodied and is 18 years of age, the state can commandeer your services for national service. To fight a war, should there be a need, to secure our borders. It's called as conscription. It has not been done in India, not as a rule, but in some of the Western countries, it is a compulsory military service. Once you have attained the age of 18 years for anyone, it doesn't distinguish between the President of the United States or the common man. Check with any President of the United States. Sovereign state. There's a time period that has been given. After you attain the age of 18, within such and such a time, you have to offer your services to the nation. 6 months or 1 year, there are certain requirements. And they would have done that service. Conscription, the government can commandeer not just your property, but your personal services for the duty of the nation. Anyway, that's international law, I will not get into it. That's why I said land is connected to everything. International law, plenty. My God. If it doesn't concern land, then there is no international. that way. I'm not onto that. And the command given to us by my colleague is only to confine to domestic law, and that is land laws being taught for our students here. So we will only concentrate on the internal sovereignty. But internal sovereignty is a limited one. As far as public property is concerned, as a general rule, the government will take care, maintain, manage, upkeep, improve, whatever it can do, use, put to different kinds of uses and all that. Private property, it can. The government can put the private property also to a different kind of use, exclusively and entirely for a public purpose. Look at that anchor, the base. If you are able to establish this, done. Right. Only thing is you have to follow procedure laid down in the law. So you have to look for that enabling law which will give you that kind of a power to put that to different kind of use. Different kind of use. What do you mean by different kind of use? Does it mean that land has a particular kind of a use? Yes. Each category of land, public or private land, by natural design, has a particular kind of use for which it can be applied. That's exactly the reason why you have something called as a forest law, forest land, forestry purposes. It's to be put to use only for that. Lakes. Lakes have a particular function to perform. For that, it should be put to use. Even private land, Town and Country Planning Act. I don't know, some of you may be having an elective course on that. What does it speak of? Under Town and Country Planning Act, the city is divided into zones where residential locality can come, where there is a locality where you have only commercial establishments, and where there is an industrial hub, like that. So land use gets predetermined in nature and facilitated by law. So you have to strictly go by law. We are a rule of law state. That's a requirement. A particular kind of a land should be put to use for which it is naturally, normally, legally meant to be put to use. Supposing you have to put that land to a different kind of a use, you have to give legal justifications, you have to show which law permits, and especially for an authority, does that satisfy public purpose? In what way the public purpose for which you are going to put this to use is different from, superior to, and justified from it has been normally being put to use. You get my point? Am I sounding logical? Okay. If you have any difficulty, and this fellow is talking very extraneous things, bring me back. The moderator has a primary duty to bring me back to the subject. Am I within the subject? Okay. It's very necessary. I'm being scrutinized by 50 odd pairs of eyes, having their own independent mind. So I have to be very cautious. That's the reason why I have some notes here. Always I will be looking up to it so that I will not stray. I have not discussed anything outside the subject. Okay. So the point is, if you want to put any public land to use as the government, even your hands are tied there, public land should be put to use for a particular purpose for which it is meant. And if you want to change the use of it, you need authorization. Lake bed to be converted into residential sites. Which law? Is there law for that purpose? There is a procedure laid down under that, and I, as an authority, I have to go by that law, whatever procedure laid down under that law. Even public property. Lake is a public property. So the governmental authority don't think that with public resource they can do anything and they can put it to use for any purpose. Sorry. This is the grammar of law, which compels him to act. Have you followed this particular idea? Have you followed this procedure? Have you this justification? Otherwise, forget it. You are in the dock. You can be challenged, you can be questioned, you can be put to inconvenience as law prescribes. Even punishments are prescribed under various laws. Hold on, you said about use of land for natural. I can understand about lake, but how do you really understand a land is of a use of a particular kind, and it should be used for that particular purpose? Law is very helpful. Law classifies land into various categories of land depending upon its natural use, utility, and value. Dry land, wet land, irrigated land. Oh, fine, fine. This we know. If I'm from the agricultural family, I would understand that. But why are you telling this to lawyers here? That is precisely for this reason that there is one law, one part of that law called as land revenue law, in which classification of land is made. Aha! So there is a legal basis for that. And you know, that law, and also if you look at some of the provisions of the land acquisition law of 1894 and the 2013, very lengthy title, you know. Right to compensation, fair compensation. By the time you have used the last word, you would have forgotten what you had said earlier. Fantastic people, lawmakers. Many a time so clumsy in making law. I think there's something called as graces of language required when you conceive of a law. I think you as lawyers may advise them as to how well they can better frame the law, and at least the title to that law should be like a window that opens up the mind of the lawmaker to look to what exactly is the content of it. You will describe everything in the title, no? The title is just like a flag, a kind of a signpost which will lead you to that. Anyway, I'm not getting into a critic, but you look to all these laws, they very clearly say that certain kinds of laws cannot be acquired. And for that, you need extraordinary circumstances, like for defense purpose, security reasons, or for earning foreign exchange, and this land is very suitable for that. Agricultural land. there is one thing that dictates our lives here. That's very Indian. We are primarily, basically an agricultural country. And that idea permeates all through the laws that we have here. And it is in support of the farmer that your land will not be disturbed unless it is inevitable, unavoidable, and we have justifications as given under this law. So I, as the acquisition officer, if I have to get your land, agricultural land, there are so many restrictions and restraints on me in getting it. In fact, in the year 2007, the government of India came up with a policy document. Whatever may be the public purpose, we shall not acquire the land belonging to a farmer for a purpose other than for which it is being used. Policies are not law, but policies is a kind of a expression of political will of the time. So maybe it's a kind of a political grandstanding in the parliament, the government of that day. Once again, I don't distinguish between a single party government or a multi-party government, whether of one description or the other description, other color or this color. Politicians are politicians. No, they come up with policy pronouncements so that it will catch headlines in newspapers. Forget it the very next day. Right? They have never really adhered to that policy that they have pronounced. And law is a little loose on that. So even agricultural land could be put to use for a public purpose of that kind that has been allowed here. So under some excuse or the other, I pick that land and create what is called as special economic zone. And there is a special law for that. In the year 2005, we made an act, SEZ Act, Special Economic Zone Act. Look into the provisions there. Beautiful law. And a little bit of that also get into this 2013 Act, which you study currently. If for purposes, for a corporate entity, if the land is to be acquired, so many members of that community in that area should have to give, yes, please you can acquire. If I don't say, we agree with you, you cannot. Can I overrule the majority opinion as is required under this law? The law also creates some exceptions. There are circumstances when I can do that also. As you go into the detail of the law, you will know. I am not going to details. I am just leading you to that. And I am just giving you the essence of that. So, acquisition is a power vested in the government for which you have a separate law. And in determining the different kinds of use of land, you have the basic law concerning land, the land revenue law, one full chapter. Which will actually have all the details about the land in every part of India. But it's a beautiful, fascinating study. In fact, as a student, I never studied land law because it was not there in our curriculum. Even as a teacher, when land law was first introduced in India, in my law school, we have the Bar Council of India also has a representation. They are part of the executive body. And I so happened to be a member of that executive body. And the chairman of the Bar Council was there, and he said, in our research committee, we took a decision that from next academic year, We are planning to introduce a course on land law. And so be prepared for that. That's what he said. Then I asked him, oh yeah, what is there to be prepared about? You have the land law course and your research committee must have advised you what should be the curriculum for that and how we should go about that. Just give us and we will prepare ourselves well in advance. The chairman said, no, we have no syllabus. Land law is a demand made by the legal profession. Land law is demand made by the government to be introduced for students of law because without that law degree is incomplete. So our degrees were incomplete. We didn't have that. Then asked who would prepare the curriculum. I think law school being foremost in India, which has been the first law school in India, should prepare the curriculum. Anyway, somebody would be doing it. I was just keeping quiet and I thought that I should not have spoken. I should simply kept quiet and sat away. Then the vice chancellor said, yeah, we are going to prepare the curriculum and Ramesh is in charge of it. I said, you are surprising me. I think we should discuss it in the faculty. And the faculty who is interested in teaching this new course will take. Forget about that. I have confidence. Sir, you have confidence, but I don't know what the subject is. Oh, no, we will have our discussion later. I assure on behalf of Professor Ramesh that he will set the syllabus and make it available for the entire country. And Bar Council would be very happy to take it. Can you prepare it in about a month and give it to us? Anyway, that's a different story. And I don't regret that. The reason why I'm telling you this is one of the driest subjects as people may feel, because I was feeling it that way. When this assignment came to me, I thought that this is something which is like incarceration, being punished for speaking out of tongue. Vice Chancellor should have spoken, I spoke. So I am being punished for this. Right? For a few days, I just did not know what to do. And I consulted many of the administrators. They said, oh, this subject, we in the administration also is part of our training. And we really loathe it because every day we have to administrate. What is new about that? That's what they were telling me. Lal Bahadur Academy, the highest. I used to go for lectures there. They also had this kind of a problem. I think as a lawyer, you should do a little bit of a general reading. I had a very senior bureaucrat friend of mine. Senior means at that time he was 75 or 76 years old. So I went to him. Look, none of you current administrators are going to help. How do I teach? He said, lovely subject, Ramesh. You must make it a point that you should be assigned the subject to teach. Sir, what is there in this land revenue? You know, that some land use, land management, survey, settlement. Survey and settlement are it's a very technical thing. And lawyers need not know what is there for the lawyer to know about that. Some surveyor would be doing that. Settlement. You just don't know the importance of it. I don't have the book with me, but I will suggest you read a beautiful work written by John Key. The Great Arc. Believe me, that was something I cherish even to this day. Had I not read that book, I would have felt same as I was feeling earlier. It is only a narration of survey and settlement of the Indian land. What is the survey of a land? And what does the expression settlement mean? I'm referring to concepts. I'm not straying from the subject. Let me see whether I have made it part of the syllabus here. For my guidance, not yours. Yeah, it's here. Because I mentioned the name of the book also. To the end, I have written it, but I'm introducing it at the very beginning itself. Survey means measurement of land and preparation of map of a patch of land derived in the area. That is survey. Settlement means to determine the rent. So, legal expressions, they carry a particular meaning. Why does the government get into a survey of land? That 40 years work narrated in this particular book is all about the struggle, travails, pains, suffering, and achievements of a group of surveyors who did go to the length and breadth of India to measure the land, determine the different kinds of uses of that land, so that later, when once this record is available, fix the rent for the state to collect. Revenue law talks about survey and settlement. I said it's a fascinating account because how Everest was measured in that book. How did the survey start? It started with a chain. See, measuring land is not a small job. In fact, some 10 years after I started teaching land law, I got the joint director of surveys to come and engage a session for my students. You should do a little bit of a practical exercise. And he said, I am not going to teach them in the classroom. I am taking them to the field. He took them to the field. He gave them a chain. I asked him, what do you do with this chain? You are going to bind us or what? No. That's how you measure the land. Why you need a chain to measure the land? He said, I can measure the land even with a thread. But I cannot measure it with scale. You know why land cannot be measured with scale? There is a curvature. Land is not plain. On a piece of paper, you can draw a line. But on land, to measure land, it has to go through those contours. And how do you measure the hill? It's a fine art, I tell you. Real skill required for that. And you cannot go to such places, especially in dense forest area, to really take that chain and measure things. You cannot even enter and you stand at the top of a hill and look into another hill which is higher than that. What the height of that? Well, there is some science in that. You don't have to go to that. And still sitting here, you can do that. Believe me, that 40 years of work of survey and settlement done by the British, later with your, what is that you have? The satellite. And what is that you have? The location map that you get on your, that was not available then there. Very rudiment instruments. Whatever measurement they did, whatever calculation they did, trigonometric things. Students of trigonometry know about it. It's an aspect of mathematics. Triangles. use of triangles and things like that. Anyway, I'm putting it very crudely because I was supposed to be very good in mathematics during my school days. That's a little bit of it I know. I can tell you. The measurement made by them, it is not even 0.1 centimeter wrong. With the advancement in science that we have today, so it is not a guesstimate they did. Those measurements. Fascinating study. The moment you start reading these provisions, you will really recall those experiences of those people. Thrilling. Law learning can be thrilling, not a dry thing. Now, my teaching can be a very dry stuff, but you reading it with at the back of your mind, having read something earlier. Most of you are Kannada speaking, right? ಕನ್ನಡ ಬರುತ್ತೆ ಕನ್ನಡ ಕಾದಂಬರಿ ಎಲ್ಲ ಓದ್ತಿರಲ್ಲ ಇತ್ತೀಚೆಗೆ ಈಗೊಂದು 6 ತಿಂಗಳ ಕೆಳಗೆ ಒಂದು ಕಾದಂಬರಿ ಬಂತು ಕಾದಂಬರಿ ಅಲ್ಲ ಅದು ಒಂಥರ ಕಥಾನಕ ಮಂತೇಶ್ ಓದಿದ್ದೀರಾ
ಇಲ್ಲ ಸರ್
ಪ್ರಮೇಯ please buy that or at least take it to your library. A bit of what you have in John Key's work is there in that. In fact, it's all about survey and settlement. Only thing is, this man has made it quite interesting. It almost reads like a whodunit. Some passages, some 40-50 pages in about 300 pages, somewhere in the middle. Please don't read only the middle part. Just because I'm telling you, there are more other interesting aspects also. It's just like a spy thriller. Learning law can be like reading a spy thriller. No exaggeration from me. There are passages which are most boring. That's also there. That's the case with our teaching also. That happens. So, if you're really interested, read a novella of this kind, which gives you hang of an idea as to what is this survey and settlement means. And certainly when you get into practice, this would be a very great help to you. Mahantesh was here when he called me for a lecture last year, and I'm making it sure that I'm not repeating whatever I said in the last class. I'm quite sure that he will see that I'm telling something new.
Yes.
I'm very conscious of it. When the audience is the same, and she was also there, he wasn't there. So I cannot fool people every time. Law is very dynamic. You learn new things and you share it with your students. Who else but your students? Who can have that sharing with you? And the more you share, more you learn. That's the greatest thing about law learning. So, when you measure, along with the measurement, the surveyor's job is to examine what kind of a soil is this, what kind of a use it's being put into, what's its value. It's almost like documentation of, that's what was the intent of the Britishers. Richness of the resource that is there in India. They wanted to know, they wanted to test us. Because the colonial master wanted to see how rich is India, not the bank balance, land. This one exercise, very painstaking, exhausting, that involved so many people to be put to work, that they had to really release at that time several lakhs of rupees, worth it. So they knew how rich we were, and by the time they left India, we knew how poor we became. The problem with us is we just don't know the value of things around us. Land revenue law teaches you that lesson. and how we should value whatever that is left with us, how we should nurture and take care of that. You also have studied environmental law, perhaps that teaches you that also. So anyway, that's about survey and settlement. I don't have time for that. And I'm not coming into the main aspect of my discussion on public purpose and acquisition. So you know the value of property, its different kinds of uses, and you want it to put to a different kind of use. Even public property, when you are going to put to different kind of use, you need to have a procedure laid down under law to observe before you do that. I said that public purpose acquisition is only generally related to private property and not public property. Even for public property, as students of environment law, you have studied forest law, right? And in the forest law, there is a public property which should be made into a reserve forest, which should be made into a protected forest, a village forest, a wildlife sanctuary. There is a procedure for that. And the procedure laid down is the same as the acquisition law, not a single procedure change. So if you master this, you would have mastered forest law. Forest law is nothing but land revenue and land acquisition law put in a very specialized way. That law. You have multiple benefit in reading this subject, in mastering this subject. Let me go to the other aspect. So the state can acquire land. Going by the old law, 1894 law, how would state acquire land? For a public purpose. And what is that public purpose? Well, at least 7, 8 purposes are mentioned. I don't have to explain. Look into the provision. You will get all those 7, 8 public purposes. Anything that would do good to public. Infrastructure, irrigation, highways, including establishment of industry. In fact, public purpose was given an extended meaning, acquisition for a company as well. Not exactly a private one. Not in the sense that you understand in the Companies Act, but company, a corporate existence, which may be involved in commercial activity exclusively, where money transactions take place, but still it has an undercurrent of public purpose in it. You are able to establish, acquire. So the state can acquire land not just for public purpose but also for a company if some of those markers of 7, 8 items that we have mentioned here are satisfied. So housing colony for the workers of a particular industrial establishment. There are plenty of case law, I won't mention any of them. If you look through the earliest of cases, is somewhere in 1965, where a housing colony for the workers of an industry is also a public purpose. So like that, you have illustrative examples of all that, which would give you a clear idea of what is the public purpose and how this is being employed to acquire land by the state. Acquisition for a public purpose may have several dimensions to it. It may be something that would actually benefit a large number of people naturally, but Is number that very significant? Not necessarily. And you have case law on that. But only thing is that which will touch upon the social, cultural, religious, economic lives of the people and add value to their lives. Public purpose. You can acquire. And you have to follow a particular procedure. Just because you have public purpose, you cannot just take it. In fact, in the United States, they don't use the expression acquisition in law. It's called taking. They just take. It's very direct, no? Americans believe in direct action. And this law speaks in that language, taking by the state, means expropriation, or another legal expression. And in the common man's language, nationalization. All these are variants of the same idea of exercise of eminent domain by the state. Private property is being taken over. All banks are nationalized. Why? They were private. And in public interest, they were brought on the public domain. It was an actual, although it was something like takeover of companies, it was actually acquisition for a public purpose. You have procedures laid down under law. Issue a notice, intention to acquire, hear objections, and then come up with a settlement package, issue an award, you have an adjudicatory body to see whether there are any disputes in relation to that, get it sorted out, and then take possession. In fact, in the 1894 Act, this was all that was there. Hold on, you just did not refer to something else. Public purpose you can acquire. Private property. And I am losing property. I am getting displaced. Does not that mean anything to the state? You need it for public purpose, fine, but what happens to me? I will be in the streets. Oh, no. The law is not that unkind. Since you are going to lose your land, you get compensation. That's a big relief. Compensation is a relief. Monetary relief. How much I will get? Well, some calculation. 1894 to till 2013, it's a very big evolution. And to put it in a nutshell, the jurisprudence emerging out of court intervention. These are the expressions used by the court. Compensation should not be a token amount. See, the government rates are different. You want a piece of land, you check about the government rates. So with that money, you go there to buy that land. The landowner says, "You are joking. These are government rates which are very modest. There's something called as a market rate." Oh, market dictates. It's about demand and supply. Pure economics. And market rates are higher than government rates. Oh, then if the government gives me money in any manner they have decided, that will not fetch me an alternative value of this dimension, of this kind. No. Then I am at loss then. Why should I suffer? Of course, public will gain, no doubt about that. But is it on my funeral? And what does the Constitution say? All the material resources of the state should be put to use. It should be accessed, used, managed, improved upon by the state, directive principle, for the good of everyone. Sabka saath, sabka vikas. That's what our Prime Minister said. A beautiful expression. That's what 39D and C is about. Equity. But what is happening in this law? Is it not unconstitutional? In fact, that was what was challenged. Any amount of compensation will not do. And how do you determine this fair and justness? Well, you have Ketina case law. In fact, much of the early amendments to the Constitution are on account of property acquisition. Keshwanand Bharti, read that. You have read that, of course. Reread that again. You will see it in a different light. People get very alert when their property is going to be acquired. If somebody else's thing or public property is lost, destroyed, degraded, nobody cares. My property, I'm very possessive. So they go to court. Courts entertain them. Constitutional courts have to decide cases of this kind. So you cannot divorce the personal interest, individual interest from the public interest. I am part of the public. I also deserve equity. So compensation, which was just throw a few coins and then move on, the British attitude of 1894, which continued even after independence for a while, got transformed. It's a social welfare state we are in. And this is the constitution which actually makes a marked departure from the colonial rule of doing anything and everything they wanted. And British never did anything illegal. And if anything was found illegal, they made a new law to legalize that. Land Acquisition Act was one such. A draconian law to start with. For anything they would use this compensation. We are compensating you. Right? What I'm going to get out of that? My status quo anteposition is disrupted. Look, this is the requirement. There were instances when the court said land for land should be the compensation. I should be put in a position at least as I was earlier economically. Status quo ante. On consideration, compensation, not consideration, compensation, you have a huge volume of case law. It is a practitioner's delight to go through it. Who said land acquisition law is uninteresting? Most interesting, and that is actually giving you a lot of money in practice. How do I earn through this? Not at the cost of anyone, but actually going to get justice done to my client who has been illogically denied whatever that he deserved. Very justified thing. And it's heightened to the level of constitutional amendments. So it's not an easy thing. Private property, how can you touch that? Unless and until, and you are not a dictator, it's a democracy, and You have to follow the due process of law, and the due process of law should have life. So from this flows that compensation is not just monetary relief to whatever that we have taken, but the loss is not just a monetary loss, but there's something called as a trauma, emotional. There's a mental element to it, apart from physical deprivation. The floor has given way. No, the floor is taken away. Forget about given away. Giving way. And so it is not sinking feeling, you are already sunk. Mentally, if you feel that, you are lost. So there is a trauma behind loss of land. We attach a lot of importance to land, not just because of its economic value alone. It is something to do with our own identity, right? ಅಡ್ಡ ಇದೆ ಜಹಗೀರ್ದಾರ್ ಏನಾಗಂದ್ರೆ ಜಹಗೀರ್ ಇದ್ದವರು ಪ್ರಾಪರ್ಟಿ ಮ್ಯಾನ್ ವಿತ್ ಪ್ರಾಪರ್ಟಿ ಸಾಹುಕಾರ್ ಅಡ್ಡ especially in northern part of Karnataka, you have such names. It's all actually indicative of the title, the position, the status, the property that one has. And your identity is getting lost. A Jahagir without Jahagir. With this. So, when once you have that kind of a trauma, let me accelerate, just 15 minutes left, and I'm not even started. I'm just beginning to open up. And it's such a fascinating discovery by us now. The loss is such that it cannot be measured only exclusively in terms of the money equivalent to the land value, market value, or whatever. So what you do? To this you have to add solatium. ಪದಗಳ ಅರ್ಥ ತಿಳಿದ್ಬಿಟ್ರೆ ಬಹಳ ಸುಲಭ ಕಾನೂನು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳೋದು. ಸೊಲೇಸ್ ಸಾಂತ್ವನ. ಮನಸ್ಸು ದಣಿದಿದೆ, ತಿಕ್ಕಾಪಾಲಾಗೋಗಿದೆ, ಮುಂದೆ ಏನೋ ಹೇಗೋ ಗೊತ್ತಿಲ್ಲ. ಕಾನೂನು ಅಷ್ಟು ಕೆಟ್ಟದಲ್ಲಪ್ಪ, ನೀನು ಕಳ್ಕೊಂಡಂತಹ ಭೂಮಿಗೆ ದುಡ್ಡು ಸಿಗತ್ತೆ, ಅದ್ರ ಜೊತೆಗೆ ನಿನಗೆ ಸಾಂತ್ವನದ ರೀತಿಯಲ್ಲಿ ಇನ್ನಷ್ಟು ಹೆಚ್ಚು ಹಣ ಕೊಡ್ತೀವಿ. ಎಸ್, much more than the value of that land I should get by way of solatium. So, if you look at the journey of this law concerning solatium under the acquisition law, it started with 1/3 of the land value when it was first introduced. Then 100%. ₹100 ಸಿಗೋದ್ರೆ ಇನ್ನೊಂದು ₹100 ಸಿಗತ್ತೆ ನಿಮಗೆ. ಯಾರನ್ನು ಕೆಡಿಸ್ತು, ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ ಲ್ಯಾಂಡ್, ಇಷ್ಟೊಂದು ದುಡ್ಡು ಸಿಗೋದಿದ್ರೆ misled. Even with that ₹200, you will not be able to get the same land. In fact, that was also the question in 2013 law. If I get double the money, will I be able to get something similar to that? Hold on, where you are losing land? I'm losing land in that rural area. Okay. Four times over. There are situations when you have to, and that's what has been prescribed as a formula. What if I lose the land in urban area? Urban area, the land value is high, so double. If it is 4 times there in rural area, double here.
Double.
ಓದ್ತಾ ಬನ್ನಿ ಗೊತ್ತಾಗುತ್ತೆ ನಿಮ್ಗೆ. ನಾನು ಅದು ಫುಲ್ ಡೀಟೇಲ್ಸ್ ಹೇಳ್ತಾ ಇಲ್ಲ. ಯಾಕೆ ಈ ತರ ಮಾಡಿದ್ರು ಅನ್ನೋದಕ್ಕೆ, ಕಾನೂನಿನಲ್ಲಿ ಬದಲಾವಣೆಗಳನ್ನು ಯಾಕೆ ತಂದ್ರು ಅನ್ನೋದಕ್ಕೆ ಅದಕ್ಕೆ ಕಾರಣಗಳು. ಕೆಲವು ಸಂದರ್ಭದಲ್ಲಿ ಕೋರ್ಟು, ಕೆಲವು ಸಂದರ್ಭದಲ್ಲಿ ಈ ಮಧ್ಯಸ್ಥಿಕೆ ಆಗತ್ತೆ. ಮಧ್ಯಸ್ಥಿಕೆಗೂ ಅವಕಾಶ ಇದೆ. There's mediation. You can even settle it out of court. Provision was there in the old law. Now it's slightly different under the new law. Under the old law, it is called as settlement outside the court, wherein whatever may be the various procedures that you follow, if I and you agree, I am the acquisition officer, I have the power to do this. Because if you get into a dispute and you know in courts, it takes years and years. So to realize the benefit of that will take a long time. Would you like to get into this adjustment? See, even if you fight it out in the court of law, paying the fee to a lawyer, you have to spend money on that. That will not be accounted for. You will get about 24,50,000. I calculated and show you. That's what the officer would tell you, and he would have done his mathematics all right. So what's your officer? 30 lakhs. Done. Consent order. That used to be the position earlier. It cannot be done now. But there are situations where something similar to consent is also possible under this new law. If you go a little probe deeper into it, even that's possible. Anyway, solatium is something added to the compensation which would more than make up for the loss. That was the journey up to 2013. ಆಯ್ತಲ್ಲ, ಎಲ್ಲ ಬರ್ಬೇಕಾದ ಕಾಂಪನ್ಸೇಷನ್ ಸಿಕ್ತು, ಎಲ್ಲ ಆಯ್ತು. ಇನ್ನೇನು ತೊಂದರೆ? ಒಂದು ವಿಷಯ ನೀವು ಬರ್ತಿದ್ದೀರ ಇಲ್ಲಿ. ನಮ್ಮ ದೇಶದಲ್ಲಿ ಸಾರ್ವಜನಿಕ ಆಸ್ತಿ ಆಗಲಿ, ಖಾಸಗಿ ಆಸ್ತಿ ಆಗಲಿ, ಖಾಸಗಿ ಆಸ್ತಿಯಲ್ಲಿ ಜನ ಇರ್ತಾರೆ. ಸಾರ್ವಜನಿಕ ಆಸ್ತಿಯನ್ನ ಸಾರ್ವಜನಿಕ ಉದ್ದೇಶಕ್ಕೆ ಬೇರೆ ಕಾರಣಗಳಿಗೆ ಬಳಸಲಿಕ್ಕೆ ಪ್ರಯತ್ನ ಪಟ್ಟಾಗ ಜನರು ತೊಂದರೆಗೊಳಗಾಗಿದ್ದು ಉಂಟು. ಜನರು ಅಂದ್ರೆ ಸಾರ್ವಜನಿಕ ಪ್ರದೇಶದಲ್ಲಿ ಜನರು ಉಂಟೆ, ಹೌದು. ಎಲ್ಲಿ? ಅದೇ ಬಂದ್ರು? ಅವ್ರಿಗೆ ಅನುಮತಿ ಇತ್ತೆ? ಇಲ್ಲ, ಅವ್ರಿಗೆ ಸಾಂಪ್ರದಾಯಿಕವಾಗಿ ಅಲ್ಲೇ ಇರ್ತಿದ್ರು ಅವರು. ಟ್ರೆಡಿಷನ್. They used to live there as a matter of tradition for thousands of years. In fact, they have been living there since time immemorial. Whom do you call them? Tribal people. Oh, in these places, tribal people were there. Okay. What is the distinctive feature? Well, there are certain criteria to identify the tribal people. They are attached to a property. So much so, it is not just about they having been born, they having been domiciled. Their very existence, their breath lies there. It is their exclusive identity. Take them out of that, they lose that identity, not just Jahagirdar kind of a thing. It's actually a kind of a genocide. You know what is genocide? For the Second World War kind. Recall that. It happened in India. Every time this land acquisition and a public place occurred, these were the victims. And what does 39 clause B and C say? Equity. What was the equity for these people? It was so iniquitous. And there were instances when A big dam were to come, these people were moved out, thrown out. Literally, no compensation also, because they did not have a title. ನನಗೆ ನಿಮಗೆ ಇರೋ ಥರ ಟೈಟ್ಲ್ ಇಲ್ಲ ಅವ್ರಿಗೆ, ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲ, ರೈಟ್. ಸೊ ಪ್ರಾಪರ್ಟಿ ರೈಟು ಇಲ್ಲ, ಆಚೆ ಹಾಕ್ಬಿಟ್ರು. ಆಯ್ತು, ಆಚೆ ಹಾಕ್ಬಿಟ್ಮೇಲೆ ಏನು, ನಿಮ್ಮ ದಾರಿ ನಿಮಗೆ, ನಿಮ್ಮ ಜೀವನೋಪಾಯ ನಿಮಗೆ, ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ. ನಿಜವಾಗ್ಲೂ ಆಗಿರೋದು ಇದು. ಹೋಗ್ಲಿ, ಹಾಗೆ ಬಿಟ್ರ? ಓ ಇಲ್ಲ, ಅಲ್ಲೊಂದು ಇಂಡಸ್ಟ್ರಿ ಬರ್ಬೇಕಾಗಿತ್ತು. ಅಲ್ಲಿ ಯಾಕ್ರಿ ಬಂದ್ರಿ ನೀವು? ಅತಿಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿದ್ರೆ ಹೋಗ್ರಿ ಆಚೆ. ಎಲ್ಲೋಗಣ ಸುಮ್ಮನೆ, ಅದು ನಿಮಗೆ ಬಿಟ್ಟಿದ್ದು, ನಿಮ್ದ ಜಾಗ ಇದು ಅಲ್ಲ, ಹೋಗಿ. There were instances when communities of people were displaced multiple number of times. You are interested in knowing that? Case studies in relation to that? You are interested in knowing about the law in relation to that, the case law in relation to that? There is a beautiful book co-edited by Walter Fernandez and Vijay Paranjpe. "30 years of development and displacement in India." It's a publication of Indian Social Institute. I don't know whether you have that. I say it because I have a little bit of a personal interest, published in 1996. Those were the early days when I had done a little bit of a work on resettlement and rehabilitation. There is one chapter written by, not exclusively by me, co-authored by me with another scholar. And also a draft acquisition, resettlement and rehabilitation bill, 1996. We are talking of this act in 2013. 1996, a draft bill is also part of this law. I mean, this volume. Read that. You get a little bit of an insight. I distinctly remember the time I and my friends spent in drafting this law. I had not known anything about resettlement and rehabilitation. This was great education for me. Months together we researched on it, and it was not our combined effort only. There were so many people who were helping us out in that exercise, but ultimate draft was by two of us. I distinctly remember sitting in Delhi, and if you go to Delhi in the winter season, you have had a terrible life. ನಾನು ಯಾವತ್ತೂ ಚಳಿನೇ ಗೊತ್ತಿರಲಿಲ್ಲ ನನಗೆ. ಮರಗೊಟ್ಟೋಯ್ತು. ಒಂದು ವಾರ, day and night we worked and prepared this draft. The World Bank and the Government of India, they said, oh, this is wonderful, we wanted that kind of a law. There's so much agitation around that people who have lost their identity, they will be very happy to have it. We will consider it and make it into law. 10 years they slept over it. Revised, re-revised drafts came after that. And from 2007 onward, once again, the legislative process began. Same politics. Nothing happened for next 6 years. 2013, when that UPA government was able to feel the heat of elections, 1 year hence. Normally this happens 1 or 2 years before elections. You just observe. Not just this party or any group. It always happens with any group. When they become a little insecure, they try something populist. Precisely the 2013 Act is that. I'm happy about a few of those good ideas that were there in the 1996 bill that we prepared finds expression in 2013 law. Not that they consulted me or anybody. They did their own homework, so they're great people. And to be very frank with you, I am the biggest critic of the 2013 Act because most clumsily drafted and most poorly administered law that if you can think of in India is this law. There are exciting possibilities as to how you can make this law work. And that's the reason why you have to take extra care as to understand this law, its background, and how it can be breathing with life and brought to life. You must know the history as to why this law came and what is its core strength. The core strength of this new law is not a linear one of this kind. Starting the acquisition process, paying compensation, taking possession. That was and settlement of disputes or whatever. That was the old land acquisition law. The new law is not acquisition law. It is victim-centric law. You get my point? From state-centric to victim-centric. And who is the victim here? The one who suffered. One who has been deprived, displaced, and who has lost his identity. It's almost like losing your citizenship, losing your parents. It's the worst thing that can happen to anyone. And that is the focus here. Who are the ones who suffer most? If the function of the law is sabka saath sabka vikas, then it should have that entity in mind, and the suffering of that should be ameliorated, for which the law should expand and then make provision for. 2013 law is that. So what did it do? Acquisition resettlement and rehabilitation are a parallel process which should begin together. In 5 ನಿಮಿಷ ಮುಗಿಸ್ಬೇಕು. ಮುಗಿಸ್ತೀನಿ, ಏನು ತೊಂದರೆ ಇಲ್ಲ. My idea is only to introduce and I won't cover. Along with you, I am discovering. And once I open the window, I think you can not only peek through that, there is a door next to it, open it, you will have a mansion for the land law. And you are very familiar with everything there because you are clear about the concepts. R&R is an integral aspect of the entire process of land acquisition. We no longer call it as land acquisition. It is a land acquisition, resettlement and rehabilitation law. Compensation is only incidental. ಓನರ್ ಅಲ್ಲದೆ ಇದ್ರೂ ಆಗ್ತದೆ, ಖಂಡಿತ ಆಗತ್ತೆ. ಅಂದ್ರೆ ಎಲ್ಲ ಸಂದರ್ಭದಲ್ಲೂ ಆಗೋದಿಲ್ಲ. ಅತಿಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿದವರು ಟ್ರೆಸ್ಪಾಸರ್ ಇಲ್ಲ. You need to establish your traditional connection. And if you belong to a particular community, you don't have to prove anything. That's the reason why when in the year 2006, it's another acquisition law, in a slightly different way. Forest Rights Act of 2006. What does it say? It's a law made for protection of the rights of scheduled tribes and other forest dwellers. ಏನಪ್ಪ ಶೆಡ್ಯೂಲ್ ಟ್ರೈಬ್ಸ್ ಯಾಕೆ ಇಷ್ಟೊಂದೆಲ್ಲ ನೀವು ಪ್ರಾಶಸ್ತ್ಯ ಕೊಡ್ತಾ ಇದ್ದೀರಾ? ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಹೇಳ್ತದೆ. It's protective discrimination. That's all, nothing. Look into Article 19, Clause 2. ನಮ್ಮ ಫಂಡಮೆಂಟಲ್ ಫ್ರೀಡಮ್ಗಳಿಗೆ ರಿಸ್ಟ್ರಿಕ್ಷನ್ಸ್ ಕೊಡ್ತದೆ ತಾನೆ 19(2). ಅದರಲ್ಲಿ ನೋಡಿ ಹೇಗಿದೆ ಸ್ಟೇಟಸ್. If any exercise of any of your rights, freedom of movement, freedom of residence or whatever, would affect the security of the nation. ಹಾಗೆ ಸ್ವಲ್ಪ ಕೆಳಗೆ ಬನ್ನಿ, ಇನ್ನೊಂದು ಹೇಳ್ಬಿಟ್ಟು ಬಿಡ್ತೇನೆ. affect the life, lifestyle, traditions, and practices of scheduled tribes. It's one of the most alive thing in the law. Why Indian Constitution is great? Because it does not leave out any single individual. See, the Indian constitutional scheme is such that it does not believe in rule of majority as the test of democracy. It, like Jeremy Bentham said, the greatest happiness of the largest number. Indian Constitution believes in the greatest happiness of everyone without any exception. Nobody should be left out. 2013 law, in letter and spirit, accommodated it. Poorly worded, poorly drafted, but can be made into a good law. But what is this resettlement and rehabilitation? I have not explained. I will do that and conclude. That is a very lengthy part. I will do it in 2 minutes. Hope you don't mind for 2 more minutes. It's lunchtime, I know. Hungry person is very angry. You are not angry with me. ಕತೆ ಹೇಳ್ತಾ ಕೂತ್ಬಿಟ್ಟಿದ್ದಾನೆ ಮುಗಿಸ್ತಾ ಇಲ್ಲ ಈ ಮನುಷ್ಯ ಅವಕಾಶ ಕೊಟ್ರೆ ಇನ್ನೂ 1 ಗಂಟೆ ಮಾಡ್ತಾನೆ ಅಂತ ಇಲ್ಲ 2 ನಿಮಿಷ. The people who are so displaced, who suffer that kind of a shock of this group, have to be resettled and rehabilitated along with compensation. ಓ ಹಾಗಾದ್ರೆ ಓನರ್ಶಿಪ್ ಬೇಡ ಏನು ಬೇಡ, ಈ ತರ ಇದ್ಬಿಟ್ರೆ ನನಗೆಲ್ಲ ಸಿಗ್ತದೆ, ಪರಿಹಾರನೂ ಸಿಗತ್ತೆ, ಅದನ್ನು ಸೊಲ್ಯೂಷನ್ ಅದು ಕೊಡ್ತೀರಾ, ಪರಿಹಾರದ ಜೊತೆಗೆ ಸಾಂತ್ವನದ ಹಣ, ಅದರ ಜೊತೆಗೆ ಇಲ್ಲಿ ನನಗೆ ಪುನರ್ ವಸತಿ ಮನೆ ಕಟ್ಕೊಡ್ತೀರಾ? ಇಲ್ಲ ಹಾಗಲ್ಲ. ಯಾವುದೋ ಜಾಗದಲ್ಲಿ ನಾನು ಹೋದ್ರೆ ಆಗೋದಿಲ್ಲ. ಇದಕ್ಕೆ ಒಂದು ನೀತಿ ನಿಯಮಗಳಿದೆ. ಕೆಲವು ಸಂದರ್ಭದಲ್ಲಿ ರೀಸೆಟಲ್ಮೆಂಟ್ ಅಂಡ್ ರಿಹ್ಯಾಬಿಲಿಟೇಷನ್ ನನಗೂ ಸಿಗ್ತದೆ, ಟೈಟಲ್ ಹೋಲ್ಡರ್ ಇಫ್ ಯೂಸಸ್ ದಟ್ ಲ್ಯಾಂಡ್. ಬಟ್ ಕೆಲವು ಸಂದರ್ಭದಲ್ಲಿ ಹಣದ ಪರಿಹಾರ ಮತ್ತು ಸೊಲ್ಯೂಷನ್ ಅಷ್ಟೇ ಸಿಗೋದು. ಆದರೆ ಈ ಒಂದು ಗುಂಪಿನ ಜನ ಇದಾರಲ್ಲ, ಇವ್ರಿಗೆ ಹಣ ಪರಿಹಾರದ ಜೊತೆಗೆ ಇದು ಕೊಡ್ಬೇಕು. ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ತಾರೆ? ಸೋಷಿಯಲ್ ಇಂಪ್ಯಾಕ್ಟ್ ಅಸೆಸ್ಮೆಂಟ್. ದಟ್ ಅನದರ್ ಪಾರ್ಟ್. I took 2 hours to discuss social impact assessment last time when I came here. ಏನು ಇಲ್ಲ, ಅದರಲ್ಲಿ ವಿಶೇಷವಾದೇನಿಲ್ಲ. ಇಟ್ಸ್ ನಾಟ್ ರಾಕೆಟ್ ಸೈನ್ಸ್. ಸೋಷಿಯಲ್ ಇಂಪ್ಯಾಕ್ಟ್ ಅಸೆಸ್ಮೆಂಟ್ ಅಂದ್ರೆ ಸಾಮಾಜಿಕ ಪರಿಣಾಮಗಳು. ಈ ಒಂದು ಕ್ರಮದಿಂದ ಏನೇನು ಆಗ್ತಾ ಇದೆ, ಸಮಾಜದ ಮೇಲೆ ಯಾವ ರೀತಿ ಪರಿಣಾಮ, ಅಂದ್ರೆ ಅಡ್ವರ್ಸ್ ಇಂಪ್ಯಾಕ್ಟ್, ಪ್ರತಿಕೂಲ ಪರಿಣಾಮಗಳು ಏನಾಗ್ತಾ ಇದೆ ಅಷ್ಟೇ. ನಿಜ ಹೇಳ್ಬೇಕು ಅಂದ್ರೆ ಇದು ಸುಮ್ಮನೆ ತೋರಿಕೆಗಿರ್ತಕ್ಕಂತಹ ಒಂದು ಭಾಗ. ಆನೆಸ್ಟ್ಲಿ ಐ ಆಮ್ ಕ್ರಿಟಿಕಿಂಗ್ ಇಟ್. ಸೋಷಿಯಲ್ ಇಂಪ್ಯಾಕ್ಟ್ ಅಸೆಸ್ಮೆಂಟ್ ಇಸ್ ಅನ್ ಇಂಟಿಗ್ರಲ್ ಆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಅಕ್ವಿಸಿಷನ್ ಪ್ರಾಸೆಸ್. ಹಳೆ ಕಾನೂನಲ್ಲೂ ಇತ್ತದು, ಆದ್ರೆ ಈ ಪದ ಇರಲಿಲ್ಲ ಅಲ್ಲಿ. ಇವರೇನೋ ಹೊಸದ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ತರಬೇಕಿತ್ತು. ಯಾಕೆಂದ್ರೆ ಈ ಮಂತ್ರಿ ಯಾರಿದ್ರು ಅವ್ರು ಅದಕ್ಕಿಂತ ಹಿಂದೆ ಎನ್ವೈರನ್ಮೆಂಟ್ ಮಿನಿಸ್ಟರ್ ಆಗಿದ್ರು. ಆ ಎನ್ವೈರನ್ಮೆಂಟ್ ಮಿನಿಸ್ಟ್ರಿಲಿ ಎನ್ವೈರನ್ಮೆಂಟ್ ಇಂಪ್ಯಾಕ್ಟ್ ಅಸೆಸ್ಮೆಂಟ್ ಅಂತ ಇದೆ. ಆ ಐಡಿಯಾನ ಇದಕ್ಕೆ ಹಾಕೋಣ, ಸೋಷಿಯಲ್ ಇಂಪ್ಯಾಕ್ಟ್ ಅನ್ನೋಣ ಹೇಳಿ ಇದು ಮಾಡೋದು. ನಿಜವಾಗ್ಲೂ ಈ ಒಂದು ಬೆಳವಣಿಗೆ ಆದ್ರೆ, ಅಭಿವೃದ್ಧಿಯ ಕಾರ್ಯಕ್ರಮ ಇಲ್ಲಿ ಜಾರಿಗೆ ಬಂದಾಗ ಇದರಿಂದ ಸುತ್ತಮುತ್ತದವರಿಗೆ ಯಾವ ರೀತಿ ಪ್ರತಿಕೂಲ ಪರಿಣಾಮಗಳನ್ನು ಬೀರಬಹುದು ಅಷ್ಟೇ. ಪ್ರತಿಕೂಲ ಪರಿಣಾಮಗಳು ಅಂತಂದ್ರೆ ಅದಕ್ಕೆ ಹಲವಾರು ಮಾರ್ಗದರ್ಶಿ ಸೂತ್ರಗಳಿದೆ. There are so many guidelines in relation to that. How do you determine? ಅದಕ್ಕೆ ಒಂದು ಸಿಬ್ಬಂದಿ ವರ್ಗ ಇದೆ. There is a body that has been created to do that assessment. There is an expert group. There is somebody who will apprise that, somebody who will approve that. It's very elaborate. Provisions are so elaborate. But once you start reading it, you can all summarize it in just 1 or 2 sentences and you're done. That's what SIA is about. So, nothing, it's a very voluminous law, but in terms of understanding, appreciating, and interpreting it for a lawyer, young minds like you, should find it very easy to do that once you know the grammar, as you are seeing now. So resettlement, is it different from rehabilitation? Yes. Resettlement is a physical act. Rehabilitation is, I don't say exactly mental one. I don't say exactly it is something to do with emotions. Yes, that's the major aspect of it. But there's also a little bit of a physical element in it. That is, it is much more than actually physically settling in a place other than from where you are displaced. But the essential idea behind these two aspects, the physical and mental, emotional aspect, combined together, is to put you in a position definitely in no way inferior to the position you were earlier. It may even be superior to that. In fact, that should be the goal. So the new law that you have in 2013, sum up, is essentially takes us in a different perspective in understanding the developmental decisions of the state, which is a must. We need to develop. And for that, all resources should be geared up for that purpose, private or public. But there is a procedure whereby, in the process of development, everyone is taken along. And that's the reason why we talk of eminent domain, we talk of public purpose, we refer to acquisition with compensation, summation, parallel to resettlement and rehabilitation. It is not just a pure human rights thing, it's much more than that. It is not just about culture and traditions, it's much more than that. It's about valuing life, valuing identity of people, and if the law can achieve that, that will be the greatest success for a lawyer like you and me, if you can help that happen. So this provides an opportunity, it's really a challenge to make this law work, but we can make it work. Forget about the technicalities used here. We don't have to bother, we will leave it to the technicians to handle that. Forget about the cumbersome procedures there. Anyway, there are administrators who will take care of that. But look into the essence of it. What is the outcome of it? What is that? It is going to result in. This is only a means to that end. Whether that end is achieved through this. If the answer is yes, the process is fine. If it is not, we come in. We come in to access, secure, and realize justice for the one who has been denied. Well, that's what our profession is about. All the best to you.
Question.
Yeah.
You talked about the customary rights wherein the people are not given a fair compensation in case of rehabilitation. A recent case wherein Haldwani, more than 50,000 people have been trespassed and built a colony over there in the railway line. And we had another recent incident of Jahangir Puri in Delhi, wherein thousands of people have encroached upon the public land. So, how do you treat these two cases in case of forest land and this one?
I got your point. I will not give you a direct answer, but I will make you think on those lines. He referred to two instances of one of encroachment and another of putting to use a particular piece of land for a purpose other than for which the people were living there enjoying. How do you react to that? Not just these two instances, as lawyers, this is what I would like to caution you. He used certain expressions. These expressions can be used by an activist very easily. They have no responsibility. They can say anything and then get away. I have nothing against activists. I have plenty of friends in activism. In fact, many of my learning is from activists on this subject. But I think we as a professional, we have a larger duty. First, when somebody tells you, as you have said now, what is that which matters to me and you as a lawyer, we should know the facts. Facts not as given in the media. You know what media speaks about, whether it is social media, print media, or visual media. We are not too sure whether they are speaking the real truth or copy ಮಾಡಬಹುದು ಹೇಳಕ್ಕಿಲ್ಲ ಅಲ್ವಾ. ಫಸ್ಟ್ ನಾವೇನ್ ನೋಡ್ಬೇಕು, ಏನಪ್ಪ ಫ್ಯಾಕ್ಟ್ಸ್, ಕಾನೂನು ಏನ್ ಹೇಳುತ್ತೆ ಇದರಲ್ಲಿ, ಇಲ್ಲಿ ಯಾರಿಗಾರು ಅನ್ಯಾಯ ಆಗಿದೆಯಾ, ಅನ್ಯಾಯ ಆಗಿದೆ ಅಂತ ನೀವ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ, ನೋಡೋಣ ನಾವು. ನೀವು ಲಾಯರ್ನ ಬಂದು ಕೇಳ್ತಾ ಇದ್ದೀರಾ, ನಾವು ಸಾಕ್ಷಿ ಪುರಾವೆ ಯಾವುದೇ ಒಂದು ಆಧಾರ ಇಲ್ಲದೆ ನಾವು ಮಾತಾಡೋಗಿಲ್ಲ, ಯಾಕಂದ್ರೆ ನಮ್ಮ ಕೆಲಸನೇ ಅದು. ನೀವ್ ಹೇಳಿದ್ರಲ್ಲಿ ಮಿಥ್ಯ ಯಾವುದು ಸತ್ಯ ಯಾವುದು ಗೊತ್ತಿಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. ಅವ್ನು ಯಾವನ ಪ್ರಶ್ನೆ ಬರ್ತಾನೆ, ಅರ್ನಬ್ ಗೋಸ್ವಾಮಿ ಬರ್ತಾನೆ, ಇಲ್ಲ ನೋಡಿ ಇಲ್ಲಿ ವಿಡಿಯೋ ಕಾಣಿಸ್ತಾ ಇದೆ, ವಿಡಿಯೋ ಕಾಣಿಸುತ್ತಲ್ಲ ನಿಜ. ಫಾರ್ ಇಂಪ್ರೆಷನ್ ಯು ಮೇ ಫೋಟೋಶಾಪಿಂಗ್. ಹಾಗೇನೆ ವಿಡಿಯೋನು ಮಾಡ್ಬೋದಲ್ಲ, ಹಾಗೆ ಸ್ವಲ್ಪ ತಾಳಿ ಸ್ವಾಮಿ ಅದನ್ನ ನೋಡ್ಬೇಕು. ನಾವು ಕಾನೂನು ಓದೋರು ಅದನ್ನ ಕಾನೂನು ಏನ್ ಹೇಳುತ್ತೆ ನೋಡ. ಸೊ ಮೈ ಸಜೆಷನ್ ಟು ಈಸ್, if there is something which is not in accordance with law, take it up. Nothing comes in the way. Challenge government action, either on behalf of the victim when he approaches you, or if a larger public interest is involved, you have the highway for justice, public interest litigation, fight it out. But before you get into any of that, verify facts. How authentic, reliable, on the basis of which can you go about it? This is the only answer I give you now because our time is up. But I think you are going to be a practitioner soon, so keep this in mind. Before anybody tries to provoke you, makes an emotional appeal, yeah, we are emotional people. Basically, Indians are emotional. Along with emotion, add a little bit of a reason. And that's what the profession is about. Good luck.
Thank you, sir. Any questions? So, sir, with respect to the social impact, the people, though the village people, villagers, when they will lose their lands, so they will get 4 times of compensation, and also they will be rehabilitated in different places. But they will not able to get the whatever the attachments they are having already with the earlier land. That is one of the social impact we need to think over that. We will get the different land. We will get the rehabilitation. We will get the money, but that attachments we will not able to get it.
I have a different answer to what my colleague raised as a problem. Let's be very clear. Do you require development? Social, economic, of every kind? If the answer is yes, then there are certain requirements. Not only we need the development, we are mentally prepared to accept that change, that development, that preparation. And what is the preparation? Change our lifestyle, change our attitude, because it's going to do good not only to you, to me as well. You means you are the rest of the public. Me, who is going to be denied this land, but I'm getting 4 times the benefit, compensation, and I'm not being forgotten. I'm still in the mainstream. My quality of life will not get affected, but my lifestyle changes. Oh, I don't want to change. It should be business as usual for me. There should be development. At whose cost? And this is your nation. We talk of we the people, we are the state. The state should improve, the state should develop, but you're not making any sacrifice. Let's not talk of sacrifice, only politicians can speak of that. I don't want to sacrifice anything, my comforts or anything. But then I needed to change a bit. Huh. It's not a cost that I pay because this cost is already factored in and I'm already paid. So I need to get the benefit. It's something like having the cake and eating it too and then crying about the cake being lost. If I'm an extreme activist, I fully agree with what has been mentioned here. I know my colleague, just like me, does not mean that. We always take positions in the classroom just to see how you are going to react as a professional. And I'm giving a professional answer here. That is it in accordance with law, as per the letter and spirit of the law? Well, this is what the law provides for. If there is something deficient in it, bring in reform. What stops you from bringing in the reform? You at least initiate the process. If something is found wanting, I don't find anything wanting here. Fine. Given the circumstances and the position in which India is poised to become, what is that? Vishwaguru. Huh? Should we not get into that? The problem with us is anything new we don't accept. And the psychology ಬಂದಿತ್ತು ಹೊಸದೇನಾದ್ರು ಬಂದ್ರೆ ಸಾಕು ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡೋದು. ಸ್ವಲ್ಪ ದಿವಸ ಹೋದ್ಮೇಲೆ ಏನಾದ್ರು ತುಂಬಾ ಪ್ರೆಷರ್ ಆದರೆ ಅನಿವಾರ್ಯವಾಗಿ ಆಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತೀವಿ. ಕೆಲವು ಸಂದರ್ಭದಲ್ಲಿ ನಮ್ಮ ವಿವೇಚನೆ ನಮ್ಮನ್ನ ಒಂದು ದಾರಿ ತೋರಿಸುತ್ತೆ. ಓ ಇಲ್ಲ ಚೆನ್ನಾಗಿದೆ ಇದು, ನಾನು ಸುಮ್ಮನೆ ಏನೋ ಕಿತ್ತಾಡ್ದೆ ಕೂಗಾಡ್ದೆ. ರಾಜಕೀಯದವ್ರು ಬಿಟ್ಬಿಡೋಣ ಇವೆಲ್ಲ, ಕಿತ್ತಾಡ್ಲಿ ಅವ್ರು ಬೇಕಾದ್ರೆ, ಅವ್ರ ಕೆಲಸವೇ ಅದು, 24 ಗಂಟೆ ದಂಧೆನೇ ಅದು. ನಾವು ಪ್ರೊಫೆಷನಲ್ಸ್ ಅವೆಲ್ಲ ನಾವು ತಲೆ ಕೆಡಿಸ್ಕೊಳ್ಳೋದೇ ಬೇಕಿಲ್ಲ, ಅನವಶ್ಯಕ. As a professional, let us just see whether in letter and spirit the law is followed. Problem with us is if we don't respect rule of law, who else would? ಬೇರೆ ಯಾರು ಮಾತಾಡೋದು? ನಿಮ್ ಲಾ ಹೇಗೆ ಹೇಳುತ್ತೆ, ಇರೋ ಪರಿಸ್ಥಿತಿನೇ ಬೇರೆ ಇದೆ. ಅರೆ ಲಾ ಗೊತ್ತೇನ್ರಿ ನಿಮ್ಗೆ? ಎಷ್ಟೋ ಸಂದರ್ಭದಲ್ಲಿ ನಾ ಕೇಳ್ತೀನಿ ಅವ್ರ ಪ್ರಶ್ನೆ, ಯಾವ ಲಾ ಬಗ್ಗೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? ಏನೂ ಗೊತ್ತಿರಲ್ಲ ಅವ್ರಿಗೆ, ಸುಮ್ಮನೆ ಮುಂದೆ ಹೇಳ್ಬಿಟ್ಟು ಹೋಗ್ತಾರೆ. ಹಾಗೇನೆ SIA ಬಗ್ಗೆನೂ, SIA procedure is terrible. I agree with you. But the basic idea is good. And what is the measure of a good and a just law professional? It is just who would highlight the good aspect of it and interpret it in such a way and steer the court's decision in accordance with that kind of thinking, rather than, oh, the law is helpless, so we throw up our hands, people are going to suffer. Well, this is not the way. That's how I see it. The drafting of the law is bad. The language of the law is weak, but we can breathe life to it as professionals. If we are very clear about these concepts, if we are very clear about the objects, if we are very clear about the principles underlying them, and these are golden nuggets of wisdom. They are like values. And just look into the situation, look into the way in which the law operates, look into the way in which the administration puts that into application. If it approximates to this, no issue. If it doesn't, you have a case. ಪ್ರೊಸೀಜರ್ ಸರಿಯಾಗಿಲ್ವಾ? ಅವಕಾಶ ಇದೆ. ಸಬ್ಸ್ಟೆನ್ಸ್ಗೆ ವೈಲೇಟ್ ಆಯ್ತಾ? ಅವಕಾಶ ಇದೆ. ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ತಪ್ಪಿದೆಯಾ? ಅವಕಾಶ ಇದೆ. We must look into the space that is available in the existing law and expand on it for doing good. That's the job of a professional. I think that's how we react to what my friend said. I don't know how you take it. I I think I started giving lecture on how a professional should be. That is not the mandate he had given me. He had asked me only to speak about this concept as to how they actually form the heart and soul of this body of law. I just made an attempt in scratching the surface. Now your homework begins. Read that up. Prepare for the profession. All the best. Okay, Neema.
Okay, sir. Just 2 minutes. Sir, 2 minutes.
Hope you did not get bored.
Yes.
Thank you, sir, for giving us such great insights on the Land Acquisition Act and the Land Revenue Act. It was a great learning experience, and we students learned a lot. I now invite upon the dais Ms. Yashaswini P. to render the vote.
Vote of thanks should exclusively be for all of you for having the shown patience in listening to me and be one with me and trying to understand this. So I don't think I deserve anything. But please go ahead.
Formalities.
The teacher insists so. I obey the teacher in the class.
Good afternoon to all. Today, as we draw this enlightening law seminar to close, on behalf of the institution, KLE Society's Law College, I am glad to be standing here to express my vote of thanks. Firstly, I would like to extend my gratitude to our esteemed speaker, Dr. K Ramesh, for his valuable speech. It was thought-provoking, insightful, and informative. In future, as well, if you could, we would be honored for your insights for other topics like this, like you did today. We are truly grateful for your presence and contribution. Thank you, sir. Thank you very much. Secondly, I would like to thank in absentia, I would like to thank our principal, Dr. J. Mallikarjun Sir, Vice Principal, Dr. Anita M.J., and Activity Coordinator, Dr. Manoj Kumar H. I would also like to thank our organizing committee and technical staff members for organizing this and event and making it a successful one.
Thank you.
And my sincere thanks to all the teaching staff members for present here. Thank you. Secondly, not the least, I would like to thank all the participants.
All of you.
who have created- Thank you.
ಯಾರು ದೂರ ಬರ್ಬೇಕು ಅಲ್ಲ
ಸರ್ ಇರ್ಲಿ ಸರ್
ಸರ್ ಸರ್ ಅಟೆಂಡೆನ್ಸ್ ದರ್ಶನಿ ಪ್ರಿಯಾ ಅಭಿತಾ ಆಂಚಲ್ ಅಂಕಿತ್ ಅನೂಪ್ ಅನುಜಾ ಅರವಿಂದ್ ಬಬಿತಾ ಭರತ್ ಭರತ್ ಗೌಡ ಭವಾನಿ
Present, sir.
ಭೂಮಿಕಾ
Present, sir.
ಆನಂದ್ ಪ್ರೆಸೆಂಟ್ ಸರ್ ದಾಮೋದರ್ ಧನುಷ್ ಎಸ್ ಸರ್ ಧೀರಜ್ ಪ್ರೆಸೆಂಟ್ ಸರ್ ಧ್ರುವ್
Present, sir.
ಧ್ರುವಾಲು ಗೌರವ್ ಪ್ರೆಸೆಂಟ್ ಸರ್ ಗುಲ್ಜಾರ್ ಪ್ರೆಸೆಂಟ್ ಸರ್ ಹರಿಣಿ
Present, sir.
ಹರ್ಷ
Present, sir.
ಕೀರ್ತನ
Yes, sir.
ಕೃಷ್ಣ ಕೃಪಾ
कुमार, निखिल, मदन नायक, मालतेश, मंजुनाथ, मनोज कुमार, श्यामुद्दीन, मेघना, मेघना डीएन, मेघना पाटिल, मोनिका, मौलपूर्णा, नागवेणी, मोहिनी नायर, नंदिनी, नयन कुमार, हेमंत, निवेदिता, निवेदिता बी, निवेदिता बी, निवेदिता, both निवेदिता present, निवेदिता बी, Vijay, प्रमोद, प्रांशु, प्रतीक, प्रतीक present, प्रवीण कुमार, प्रीति, प्रियदर्शना, प्रत्युषा, राहुल, राकेश, रक्षा, हेमंत, रेणुका पाटिल, रेणुकेशर, ऋतिक, रुचिता, संजय, सचिन, सचिन संजय, yes, सचिन, सचिन also, सचिन is present, Sarana, संपतो, संदीप, संजन, संजय, धर्मप्रिया, शबरीश, श्याम, शमिका, शमिता, श्रीधर, yes sir, श्वेता, yes sir, श्वेता, कार्तिक, निखिलेश, श्रीराम, सुमन, स्वाति,
Yes, sir.
रयन, मौनेश, टाइगर, present sir, उषा, वर्षा, वरुण, वरुण राज, यशस्विनी, यशवंत, यतीश, present sir, गौतम, yes sir, thank you so much.
अरे लल्ला हाय ಅಲ್ಲಿ ವರ್ಷ ವರ್ಷ
अभिषेक यस
ಶ್ವೇತಾ ಕೊಟ್ರೇಶ್
आदित्य नारायण आदित्य सरवण दिनेश कुमार अक्षय
Yes, sir.
अक्षय
Sorry, sir. Sorry.